During this show, we talk extensively about EU-US data transfers. On December 13th, 2022, this is since our podcast has been recorded. The EU has released the actual draft decision, which will go to the EU courts. And once approved, it will form the basis of a final framework that will go into effect in 2023. At the time we recorded this podcast, there was no text. So now we have text that people can mull over until this framework is finally adopted by the US and the EU. Enjoy the show. Personal views and opinions expressed by our podcast guests are their own and are not legal advice or official statements by their organizations. Hello, my name is Debbie Reynolds. They call me the Data Diva. This is the Data Diva Talks Privacy podcast, where we discuss data privacy issues with industry leaders around the world with information that businesses need to know now. I have a special guest on the show, David Heinemeier Hansson. He is the co-owner and CTO of 37 Signals, which is the maker of Basecamp HEY. Nice to meet you.
Thanks for having me on the show.
Yeah. I'm very excited to have you on the show. I received a news feed article that you had written about kind of Europe and data transfers, and it sort of came through my phone like a lightning bolt, okay? Because I have conversations with people all over the world around data and stuff like that, and so things that people say in private and they say in public are totally different. And I feel like you just really just kind of open the curtain on that in terms of, not only someone who's in Europe, but also a business person that is impacted by all these different, regulations or machinations of what people think privacy should be and how to solve this problem. The thing I've always said is that privacy is a data issue. It's not a legal issue. So trying to shoehorn it into kind of a legal thing doesn't really solve the problem. But before we get started, I would love for you to tell me kind of your journey in technology and sort of why privacy has become an issue, or why it's kind of such a visceral reaction from you around this privacy topic.
Yes. So I've been working with the internet and on the internet since the early to mid 90s. So the functions of the internet, the privacy on the internet, all the factors of the internet is something I care a lot about. I also happen to be a co-owner of a technology company that makes SaaS software that is downstream from all of these regulations and questions about privacy and deliberations about how we should do it. Now, on top of that, I happen to be a Dane who's currently in Denmark, co-owning an American company. So I kind of feel like I have a foot on each continent, and therefore also an opinion about how these continents collaborate or not. And when this whole thing got going, which really, to wind the clock back, was 2013, Edward Snowden reveals the NSA collaboration, the tapping into the cables, the wholesale collection of data from anyone around the world. That was something that was, first of all, fascinating. Second of all, perhaps horrifying to me as a person on the internet to know that this was essentially what was going on. And I remember thinking at the time, I wonder what the Europeans think about this. I wonder what they're going to do about this, because here is a sort of sovereign bloc that can make its own rules about how it wants to collaborate with partners and other countries, really, when it comes to these issues. And the EU had long taken a much harder stance on privacy matters online than the US had. And now here was really a case that was going to put that to the test. Well, it just so happened that test would just take years and years and years to roll out. It would work its way through the courts, the European Court of Justice, Max Schrems, who was the privacy activist who brought these cases before the court. It just rolled on and rolled on and rolled on. And then suddenly we had this news that the European Court of Justice says, like, you know what, this privacy shield, this agreement that America and Europe has for exchanging data is actually void. It's not based on something that's valid. You have to figure something new out. And I remember thinking at the time, wow, that is such an earthquake. Like, what does this actually mean? Like, how can we even reform this? Are the Europeans ever going to tell the Americans what the NSA can and can't do? Like, would the Americans ever listen to something like that? That sounds interesting. It sounds like a real battle. Now, when I first learned about that, I was actually surprised about how little happened. You have this tectonic earthquake ruling that is basically from one day to the next saying, like, the way you've been operating all along is illegal. But then, in perhaps typical European fashion, just leave the conclusions unended, unwrapped up. It's like you're watching your favorite movie and you're like, they're going to explain everything, right? And then the final scene just comes before any of the conclusions. Like, what happened to that guy? What happened to that woman? What happened to the plot?
Right.
And the European Court of Justice is just like, well, I don't know. We just said it was illegal. It's your problem now.
Right.
And we've been wrestling with that problem ever since.
So this is interesting. I love to talk to people who have been dealing with privacy issues since before GDPR, like you and me. So when that happened, I was also just shocked. I couldn't believe that agreement got knocked down, right? But you're right. So they sort of left businesses to hold the bag. They're like, well, I don't know what you're going to do, like within, the months. And I couldn't believe that it went on. I think it was like 3 or 4 months before Privacy Shield came about. And like, so, literally businesses were doing business one day and just had to stop what they were doing and try to figure something out and sort of scramble and figure out what they wanted to do. I think also one other thing that happened as a result of that, and I think we're still seeing the effects of this, is that at the time that the safe harbor was invalidated, I think they had around almost 11,000 companies signed up. But once the Privacy Shield a couple months later came on board, I think only like half of those people signed up again, right? Because they were like, this was just bananas. We still have to do business, we still have to do trade, but then we just don't have any guidance really about what needs to come next. So tell me about what did companies do during that little period, like I think it was like 3 months or something, where there was just no agreement or anything.
Well, I don't think they did anything. The vast majority of them didn't do anything. I'm sure there were absolutely countless of meetings held. I'm sure there were a lot of lawyers running up some monstrous bills to the largest corporations. But everyone else, the vast, vast majority, just didn't do anything, because what were they going to do? Right? Like, there was no guidance, as you say. There was no clear, what does this mean? No one in power or authority were willing to draw the conclusions from that. And really, to be frank, that wasn't just those few months between Safe Harbor and Privacy Shield. It was all the time afterwards, because even during Private Shield, it wasn't entirely clear what this meant. It wasn't entirely clear how it related to the verdicts that had come down. And everyone was just looking around like, what are you doing? What are you doing? Can we just do whatever you're doing? I think there was just such a level of confusion, yet in a way of a status quo confusion, right? Like, if we're all confused, but we're trying, presumably nothing will happen, which, to the best of my knowledge, nothing really did happen. During that interim, even though there were obviously not just the thousands of companies who didn't make the transition from Safe Harbor to the Privacy Shield, but everyone else who technically weren't in compliance, like, what? Then what? Nothing. Absolutely nothing, right? Like, when the legislation is so vague and the enforcement is so absent, of course, people are just going to go like, I don't even know. Let's just wait and see. Except, of course, for the few companies that Max Schrems and others took to court under these protocols and basically said, like, hey, that's not in compliance. We want to get this invalidated. And I think the main thing was with Facebook, Schrems taking that course up. And I think everyone was right, in essence, to do nothing. That's the thing. That's the tragedy of this, is when there is no clarity, neither on what does this mean or how is it going to be enforced. How can we plan anything? How can businesses take a quarter of it? Are we going to let individual businesses of all sizes, interpret the tea leaves by themselves? Well, how does that make sense? How is that a good use of anyone's time? It just seems like it was just such a dark hole for, again, bullshit work, in essence, right?
Yeah.
Like a bunch of stuff going back and forth, standard contractual clauses that meant nothing, that weren't enforceable, that were never going to be enforced. Just this busy work where we all pretend, hey, we have to be in compliance because technically the penalties are quite severe or can be severe, even though no one has, in the best of my knowledge, actually suffered any of those penalties ever, even the likes of Facebook and so on these two specific provisions. So
Yeah.
we looked into it, right? So I run a software company. We have these two SaaS products. We sell in Europe. I am very sympathetic to the underlying mechanics here. I thought the Snowden revelations were horrifying. I thought the EU was right to say, hey, we're not going to stand for this. We're not going to have our citizens be spied upon in this way. We're going to act upon it. So I'm all sympathetic to what's going on here. And then I still go like, yeah, but what? What do you want me to do? What do you want us to do? Be clear. Say it one way or the other. Either there's going to be an iron curtain here of privacy that comes down and like, okay, trade in this way will stop. That's a very draconian outcome that I think very few, even European politicians, had any appetite for. What, are we going to provoke a trade war here? What's going to go on? But at the same time, they're obviously beholden to what the law of the land says, the law of the union says. And when the European Court of Justice comes down and says, like, hey, you can't do this. This is not in compliance with our setup here. You have to do something. But no one had the courage. No one had this stomach to tackle the issue head on. So we just spent years and years in this muddling phase until, again, the court comes in and says, like, no, you're still not in compliance.
Right. So two things I want your thoughts on. I'll give my thoughts. So there are two striking things about all these Schrems cases and what's happening as a result of them. One for me is that although it's definitely an interesting bit of kind of legal maneuvering and legal thinking, it's very untethered from the reality of technology, of how actual data works. And then the other thing is, you as a company, you can't stop, the FBI from busting into your organization, right? So it sort of puts the onus of trying to prevent that on a business owner. And that, to me, I feel like that should be something that should be handled between the governments, not a business person. What are your thoughts?
I completely agree. First of all, this confusion around the data is one of the things that actually prompted me to write this in the first place. We would get outreach from European companies saying, are your servers in Europe? Where are you storing your data? Can you store your data in Europe? And I would try to explain over and over again, listen, it doesn't matter where the servers are, whether they're in Virginia or in Berlin. The legal authorities in the US will have access to that data, especially for applications accessible over the internet. It doesn't matter where it physically is. In fact, I couldn't tell you exactly where the data is within the US for the services we use. We use AWS's S3 service, and it has this region set up where you have redundancy and so on. So like the physical pinpoint accuracy of where that data is, I couldn't even tell you. What I can tell you is that if US authorities show up with a legal basis for getting any piece of data from us, as an American company, we are obliged to do that. There is not another way. So if you're dealing with an American company, they are in the jurisdiction of American courts and American law, and as such will turn over any amount of data, regardless of where that data is stored. So it just frustrated me that there was this shallow understanding that if just the company would have the servers in Europe, all our problems would be solved, because then there wouldn't be this data being shot back and forth. And you're like, it doesn't matter. We looked into this exactly. When all this came out, we had our legal team look into, can we put the data in Europe? And they're like, yeah, you can, but it won't matter. And then we were like, can we wrap the data that is in Europe in a subsidiary that is a European company? Yeah, that won't matter either because it's still a wholly owned subsidiary. The U.S. government can still order the holding company to get that data. So all the protections we looked into were essentially sort of a dead end. You cannot protect under the guidance of what the European Court of Justice is talking about, that data that is liable to American intelligence services, that's a problem. You can't protect that as an American company. But that was what really pickled me. These European companies obviously were not interested in drawing that obvious conclusion. They were not interested in saying we can't buy any services or products from American companies that store that data, wherever they might store it. That we can't buy services or software from American companies. That would just be a catastrophic conclusion from them. What? They're going to give up their Google Docs. They're going to give up their Microsoft email. They're going to give up all these other things that they have, all their Apple Cloud services. So it was much easier for them to simply go like, I will put their head in the sand like an ostrich and just say, I won't deal with the problem. I will just choose to interpret the problem as one of, is your data physically in the EU? Because plenty of these large companies will make proclamation to that effect. No, Microsoft, the Outlook email you're storing is actually in Dublin or whatever. And then they go, okay, that's enough. I don't want to know anything more than stick their hands in their ears and go, la, 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 la. I can't hear anything else. Now we're good, right? Now this is not something I have to worry about again. So that part, that confusion that where the data physically is located, that means anything in any practical or even philosophical sense was just nonsense. And I wanted to shoot that down, not for our particular purpose, but for all the European companies that were wasting their time requesting this information or guarantees from their American vendors.
Yeah. I also want your thoughts on encryption. So this train of thought just grieved me greatly when I heard people say this. So they were like, okay, the way we're going to solve this issue is that we're going to do encryption and then we're going to keep the keys in Europe and then throw the data into the US. And I'm like, that's not a solution. what are your thoughts?
It's not a solution for a ton of things. There is a limited number of cases where, like, technically it is the solution. If you can encrypt the data and you're doing the encryption and you're holding the key and you're the only one holding the key, then yes, you can technically put that data wherever you want, as long as that data is sort of all inclusive, as long as there's not metadata that actually reveals connections between the data, which is often the problem. But that doesn't help you use any services from Google Docs. It doesn't help you use Microsoft Outlook. It doesn't help you use Apple's iCloud services, because none of those services operate in a way that end-to-end 100% guarantees you that as long as you hold the keys, the data can't be accessed. That's just not how any of these things work, because it's very difficult to make things work like that. There is a tiny handful of platforms, including things like Signal, that truly does operate in that way. It takes an incredible amount of diligence to get there and a very hardline way of staying there. You can't, for example, offer search. If you're encrypting all the data that you have and you're accessing that through a web application or something else, you can't allow that data to be searched, because now the application has to know what's in the data to index it such that you can be able to search it. Very few people are willing to give things up like search. So in theory, yes, if you held the keys and you were the only one holding the keys and the data was in its own little box, not connected to anything, and it wasn't being used in connection with any services, you could do it. But no one works like that. No one operates like that. And ergo, it's another smokescreen for the fact that you can't do this protection. It just doesn't work. In fact, even a lot of forms of encryption, like encryptions over the internet, the NSA, the Revelation 2013 revealed that, yes, if they just tap in at a deeper level, like say have a computer in the AT&T data center directly before things are encrypted or decrypted, it also doesn't matter. So these are sticky, difficult, hard questions, but that's why we have governments. That's why we have courts. You're supposed to adjudicate on these issues. You're not supposed to just kick the ball to every individual company to do this sort of root cause analysis of, is this actually secure or not? Is it not secure enough? And it just frustrates me to no end that if you want to have these principles, which, by the way, I have the utmost respect for, I don't know what the economic consequences would be if the EU went hardline on this. They would probably be quite severe. But if you have these principles, you also have to live them. Otherwise, you got to throw out the principles. Otherwise, you just got to come clean and say, okay, this is just too hard. It would be too disruptive. We don't have the power to force American intelligence services to abide by our standards. So we're going to give it up. Yep, this is just a fact of business. If you want to do business with American services, you have to accept the risk that the American intelligence services might tap into that. So be it.
Yeah, right. And I think especially for smaller people, I'm sure smaller companies that aren't kind of the Googles, Facebooks or whatever, I know people hate when you say this. Like what is even the chances that you'd ever have
Yeah.
anything that anyone would be interested in? I just don't know.
I mean, it all depends on like which services or who's your customers, who's your users, right? There's a reason everyone from like lawyers to human rights folks and so on use Signal these days, because it does offer at least some of the best guarantees you can get. And it's always hard to know. But I think you still have to accept at least that these small companies, and not even small companies, even medium-sized companies, you actually have to be an enormous company to really have the wherewithal to even take on a project, like figuring out how is this actually going to work? What are we actually going to change? So my advice would simply be, for now, ignore it, which is just a tragic kind of conclusion to a topic I care deeply about. Like, I would actually really like that we had some principles that we stood hard on. Mm-hmm. But for any individual company, should they go out and hire a lawyer to do a root cause analysis of what the latest, DPAF, or I forget the abbreviation, there's so many these days, for the latest announcement that came out of the White House, which is frankly just a political declaration, doesn't even have anything beneath it. There's not actually a text. No. It hasn't been tried in court. There's nothing of substance actually beneath it. Should they go out and hire lawyers to interpret that and figure out what to do? No, they should not. They should just ignore it.
So when this came out, so I think it was announced between the EU and the US earlier in 2022. Then before the election, wink, wink, they said, "Hey, we're closer." So now we have kind of a framework, and it's so funny because I saw an article yesterday where it said, "Oh, now companies have like a clear path of what they're going to do between Europe and the US." And I'm like, there is nothing. There's not a word on a sheet of paper to give anyone any instruction about what they need to do different or whatever. And I'm like, what are you guys talking about? This is just bananas.
But what's so fascinating about analyses like that is this is what everyone wants to believe to be true. Desperately want to believe to be true, that there now is clarity, that there is a framework, that people have figured this out, that we're in the clear, because the consequences of realizing reality, as in it's a total mess, no one knows anything, nothing has been decided, none of the core principles have actually put into action, is not only depressing, but expensive, disruptive, all these other things, the things that businesses hate, right? Full of uncertainty, potential mega penalties, potentially mega bills from lawyers, like all the things that businesses hate, right? Is now a good time for us to inject that level of uncertainty into everything on top of what else is going on in the world? No, it's not. But the lack of courage from both sides to simply say, what's what? For the Americans to say, hey, do you know what? Our intelligence services are going to do whatever the hell they want because we're a sovereign country and that's just how it is. Deal with it. And for the Europeans to either go like, yeah, okay, then we're just not going to allow our companies to use your services, or, okay, fine, you got us on that one. Just have the courage to reach the obvious conclusions, but pick a path. No one wants to pick a path. Everyone wants to pretend that things are being solved, even though we don't solve anything. All we're doing is creating busy work full of intentions that are going to be tested by the European Court of Justice when Max Schrems inevitably files his appeal on this stuff. And they will probably reach the same conclusion again. Yeah, you didn't solve the underlying discrepancy between how we view data and the rights to it.
Right, exactly. My feeling is that, I thought if we do ever have an agreement, it just has to be more narrow, right? It can't be this huge thing, like this all encompassing text. It's like, look, we're gonna do this, we're gonna come up to some narrow path where we can say, we try to, protect people's rights. Also, one thing I want to mention, I want your thoughts on as well. It's so funny. So when I talk to a lot of people in Europe, they're like, well, we want, with the privacy shield or whatever the hell we're going to call it now, it's like the transatlantic agreement. We want to have the same rights that Americans have. I say Americans don't have rights. We can't go to court around this type of, if NSA takes our data, there is no redress for us in America.
You don't have standing.
So it's like, you want what we have and we don't have that, right? So that's why they're trying to create these little courts within, the Justice Department or within,
right,
the FTC to try to make it seem like, oh, you have like this court process or whatever. It's like, we don't have that right. Privacy isn't a fundamental human right in the US. And I can't go to court and say, hey, the NSA took my data, I need transparency. So, I just feel like we're going in circles around this whole issue.
We are. And I think especially this fact, like, we want the same rights. The rights to what? A kangaroo court that operates in complete secrecy and has a 97% win rate for the people requesting access to data. That's not due process. That's a kabuki theater of due process, right? That's not what you want. But I think it's also just real politic here to go, can you get what you want? Can you get European styles principles enforced on another country? No, you cannot. There's all sorts of things both the US and Europe would like to change about China. Do they have the power to change those things? No, they do not. These are sovereign blocks, and they will absolutely set the course that they feel is right, whether through a democratic process or an authoritarian process or whatever process they have going on for them. But Europe simply does not have the right, well, not the right, but the power to tell the Americans on this level, and something as fundamental as this, how they should do about it. So the only option they really have is to say, okay, well, we will just not allow you to our companies to deal with that, but they're not willing to do that, right? Because the consequences of doing that are just high. And this is just one of those things. Again, I want this to be true. I would love for us to have these basic human rights of privacy. It's something I care extremely deeply about. When we built our email service, hey.com, it was one of the things I put the utmost emphasis on. The way we dealt with encryption, the protocols that we had for employees, how they could access the data, the way we went in specifically to analyze emails that you received, find the spy pixels the company used to detect when you opened your email, where you were when you opened your email, how many times you opened your email, and all this incredibly invasive privacy bugging that happens in email. We went in with hey.com and we said, like, we're not going to have any of that. We're going to lay down the land here. And when it came to these spy pixels, we would name and shame. So if you have a hey.com email address and you receive an email from someone who's using a spy pixel, we'll detect that and say, like, hey, Debbie is trying to send you an email, but she included a spy pixel. You should just know that she can see when you open your mail, all these other things, like raising the bar here. So this is something I care so deeply about. But at the same time, I also accept the limitations of the international system. The US can't make China do very many things that it wants them to do. China can't make the US do a lot of things that it perhaps wanted to do. Such is just nature, and accept that that's the fact. But it's so politically inconvenient to simply go, hey, we have principles, but they're too expensive. It's too expensive for Europe to live up to its principles. So we will just dance around it and make this little theater and pretend internally that we're living up to our principles, even though we accept the fact that reality is just different and the Americans are going to do what they do.
That's true. And it is very expensive. So, I work with companies. Some people this is interesting. This is an interesting story. So I guess there was a church in Europe that they decided they weren't going to do prayers from people anymore because they felt like it was going to be against GDPR. Like if they call a person's name out. I'm like, see, this is just
What?
crazy. Like you just going off the
Oh my
reservation. So
God.
I feel like
Yes.
some people just take this way too far. It's like, you still have to do business. You still
Yes.
have to make money or and so you can't fight punch upward to an intelligence agency. So I think the best thing to do is try to find a way to do business as transparently as you can and not rack up all this busy work for yourself.
That's the part that really just offends me, is when the busy work doesn't lead to any fundamental new protections. If all this work that companies were doing on standard contractual clauses or any of the other stuff in the interim, analyzing a safe harbor, analyzing privacy shield, analyzing Schreem's verdicts, if any of that actually led to any fundamental improvements in privacy for regular people, I'd go like, okay, fine. But it does not. All of that busy work is just sort of self-contained in its own little bubble. It has no impacts on the real world. And that is just frustrating beyond belief that we're wasting human potential and human capacity in such unproductive ways. So let's stop doing that. And again, my plea as a fellow business owner who has one foot in Europe and one foot in the US, ignore this. Ignore this for now. One day, maybe there'll be some clarity and there'll be some real regulations that actually have an impact and help someone somewhere do something. That's the time to engage with it. Now, I understand that's not a plea that can be heard by everyone, and compliance and risk and all these other factors play in. But at least to the small and medium-sized businesses, just ignore it.
You're so feisty. Oh my goodness. I totally love this. So if it were the world according to you, David, and we did everything that you said, what would be your wish for privacy anywhere in the world, whether it be human stuff, technology, law, anything?
I think the fundamental right to privacy is something all humans should have. And to me, it comes down to two practical things. If you want the data of someone, you have to go through the courts. It has to be a due process. There has to be a warrant, and the warrant has to be specific. We cannot have general warrants. General warrants, by the way, was one of these things that at the founding of the US that people were very much against, because general warrants where you just have this dragnet, which was what Snowden revealed that was in place, the dragnet where you just pull in everyone's data, guilty, not guilty, probable cause, no cause, it just all gets sucked in, is a dystopian, horrible place for us to live. This notion that, like, are they watching us? Are they listening to us in our everyday conversations? It's just an oppressive regime to live under. Again, there are criminals that commit crimes, and as such, during the investigations of those, it should absolutely be possible for law enforcement agencies to get a judge to sign off on a warrant. Fine, we're good so far. That's sort of the legal part of it. And then the other part of it for me is around the sort of the biggest mass scale invasion of privacy, which is what happens under surveillance capitalism to drive the advertising regime that we have on the internet. That to me is something that should be banned. This idea that you can target ads on the basis of people's personal information is what leads to all the abuses in the first place, because it's what makes those abuses profitable. If it was no longer profitable because it was no longer legal to use that kind of data for targeted advertising, I think the whole regime would just collapse. It would be too much work, too much risk to wholesale just aggregate all of this data, run it together, as we have all these cases with Facebook combining all sorts of data sources together and buying data from here, there, and everywhere. They do that because it informs a regime of extreme ad targeting. If that regime was not something that Coca-Cola and Pfizer and General Mills and all the other large advertisers could use because that was simply illegal, the whole thing would fall apart. We have to change the incentives. And currently, all incentives on the internet is collect as much as possible from everyone you can and hold it until eternity. That is a catastrophic vision of privacy. So if we deal with those two things, away with the general warrants, away with the dragnet surveillance, scale it back to targeted warrants, and ban surveillance capitalism in its current form, that to me are the two most meaningful steps we could possibly take.
I agree with you wholeheartedly. I think you've been listening maybe to some of my work. So I've said that for a long time. And, I think all this over surveillance of people is creating like a guilty until proven innocent type of thing where you have to
Yes.
kind of fight your way out of something. You against the algorithm who says you did X, like, oh,
Yes.
David walked past the coffee shop that got robbed. Like he's a suspect now. It's like it's
Exactly.
bananas. It's ridiculous.
And it's
Absolutely.
not a world anyone, I think, really wants to live in. This is
No.
the other thing. I don't actually believe that this has broad public support, that we go like, okay, we're going to trade our liberty and our privacy for a modicum of security. That modicum of security has repeatedly, time and time again, been disproven. One of the things that came out of these Snowden revelations was how often were these major plots being stopped by us spying on everyone. And the number of times they could come up with any compelling cases where we're like, yep, here's a case where the dragnet totally worked and we stopped some atrocious thing. It basically didn't happen, right? So we're trading this enormous human vulnerability by giving up our privacy for what? For not even a material increase in safety. If we had suddenly gone from like, okay, every other day there's bombings or terrorist attacks, and then boom, we put this dragnet in place and they stop. Some people might go like, all right, I'm willing to trade some of my fundamental human rights to stop the madness. Just wasn't reality.
Right.
So we're trading in most cases for a phantom idea of safety with a very real conception of privacy. It's a bad deal.
It is a false dichotomy, right? The trade between safety and privacy. So, well, thank you so much. This has been an electrifying conversation. I love to find ways we can collaborate together. You're so much fun.
Excellent. Absolutely. I really like being on your show. Thank you.
Thank you so much. We'll talk soon.
All right. Sounds great.